So if the UK Constitution isn't all written down in one place, there's not one source for the Constitution, then what are the sources of the UK Constitution? So a quick recap. The UK has an unwritten constitution, an uncodified constitution, meaning it's not all written down in one place. It therefore has no special legal status. It's more of an ethereal concept rather than a specific block document. And there are pros and cons to both a codified and uncodified constitution. And the UK did have a codified constitution following the English Civil War, and there's also arguments about other different legislations and documents that have existed in the past, like the Magna Carta, for example. Because the UK Constitution is unwritten, i.e. not all written down in one place, it means that its origins is in a number of sources. We'll look at 5 of them today. It says 4, but we'll have a look at 5 of them today and identify the most important aspects of each of them. So the first source of the UK Constitution is statutes law. Okay, these are all, by the way, in no particular order. Some have a different weighted value than others. However, I'm just doing this in order, in no particular order. So statute law is the first source of the Constitution. From the 16th century, it became increasingly established that Parliament would be the supreme lawmaker, the legislature, the branch of government that creates legislation, statute law. Statute law consists of all the pieces of legislation passed by Parliament. However, some statutes are seen as more, quote, constitutional than others. So, for example, the Human Rights Act, the Bill of Rights, the European Communities Act, the Constitutional Reform Act. These are all examples of statute law that are seen as more constitutional than others. You could also argue, but less so, that things like the Police and Criminal Evidence Acts, or Road Traffic Acts, all these are also technically make up the Constitution. However, these kinds of pieces of legislation are seen as more constitutional. The Acts of Parliament that raise constitutional questions are the ones that therefore shape and form part of the Constitution. There is also debates about certain statutes being constitutional, not just merely by them raising constitutional questions. So in Thoburn and Sunderland City Council, 2002, the case, referencing the European Communities Act, the idea of constitutional was described as meaning a statute the courts will not read as overridden by other statutes unless very clear language is used. So what this means is some statutes can be part of the Constitution whilst not be seen as constitutional. So in this case, for example, the idea of constitutional was simply described as being not overridden by other statutes. Okay, unless very clear language is used, unless it's very clearly written that it has been overridden. Okay. Now, a more complicated source of the Constitution is the common law. The common law is a body of law which is developed by judges on a case-by-case basis. It claims legitimacy as it embodies the values of the community given shape by precedent. Okay, so every single case that is heard by a judge sets a precedent. So by setting a precedent, it means that other cases in the future that are maybe similar or have similar principles, you can refer back to the previous cases to see what the laws were, or what the precedent was, what the decision was, and you can use that to shape your decision in your case. Okay. Historically, the common law predates Parliament. The common law has been developed for thousands of years, and it has its roots in ancient Roman jurisprudence. Okay, so the common law has been something that has been developing in the UK for thousands of years. There are also aspects of Roman law that we see today within our common law system. So it has thousands and thousands of years of historical precedent building upon itself and building up and up. However, there is still tension between common law view, two different views of common law. The common law view championed by judges such as Coke, who lived in the 1500s, and Blackstone, who lived in the 1700s, and the modern political notion that power is vested in Parliament. So the older generations of judges argue that the common law is a supreme, a more interesting, what's the word? It's just a more powerful part of the Constitution than the statute law. However, modern politics has developed the idea that Parliament is the sovereign lawmaking part of government. Okay, so it almost takes a step back. The common law does. Another really important source of the UK Constitution is constitutional conventions. Now, conventions are just generally rules and principles which are not legally binding, but nevertheless are accepted practice. So conventions are only binding by virtue of their acceptance by those in power. The importance of constitutional conventions mainly deals with the relationships between the three branches of government. And like we said, the three branches of government are the executive, the legislature, and the judiciary. Okay? So there are a few main conventions. It's better for me to explain what a few conventions are, for you to get a better understanding of what the idea of a convention is. So conventions relating to monarchy ensure that vestigial prerogative powers are normally exercised only in accordance with advice from ministers. So the doctrine of, we'll go back we'll just talk about this in a little bit more detail. So the monarchy to ensure vestigial prerogative powers are normally exercised in accordance with advice from ministers. So this is the convention that the monarchical prerogative powers can only be used if they have been given advice from ministers of government. Okay. Now this is a very interesting example because at time of recording we have just gone through the issue of the prorogation of Parliament. Okay, so in September 2019, the Prime Minister Boris Johnson sought to prorogue Parliament, which is to dissolve Parliament effectively for 5 weeks during the Brexit negotiations. Many people, many politicians and political thinkers argue that this is an unusually large length of time for prorogation. Prorogation generally happens this time every single year. However, it's not for 5 weeks normally. It's not been this long for the last 70 years. And it also is something that's quite interesting because of the political climate with Brexit happening at the end of October. Okay, so the idea is that the Prime Minister was only allowed able to prorogue Parliament with the prerogative power, the power from the monarchy. So this convention has really been called into question because if ministers are advising the monarchy to, in this case, prorogue Parliament for their own interest, then surely there isn't there a conflict of interest within that system, because only the monarch only gets advice from her ministers. Okay, so the Queen only gets advice from ministers. However, if the ministers are the ones that are wanting this prorogation to happen, then isn't there a conflict of interest there where they're effectively advocating the monarch for this and have a sort of political agenda? So that's really what some of the arguments have been about, and it all does relate to this convention, the idea that the monarchy can only exercise her prerogative powers if there is accordance with advice from ministers. So we might see some development of this convention in the next few months. When it comes to the doctrine of ministerial responsibility to Parliament, this was created through a chain of conventions. Okay, so the idea of collective responsibility, which means that the cabinet must show a unified front in policy decisions. You can't have a cabinet in which some ministers disagree with the policies and some agree with the policies. If you disagree with the policy, you can either talk positive about it publicly, or you can resign. They're the two options really that the idea of collective responsibility brings about. Okay. There's also the very important Salisbury Convention, which requires the House of Lords that they should not oppose a measure sent to it by the Commons, which is a part of the government manifesto. So the Salisbury Convention states that if a law or a policy is in the government's manifesto, then they shouldn't be allowed to oppose it when that piece of legislation comes to their chamber. Okay, so these are all examples of different rules that aren't set in law but are considered to be binding in law, or should we say binding, politically binding, because they have just been the accepted practice. Another source of the Constitution, the fourth source of the Constitution, is a little bit less important, but also sort of sways upon different rules that have been made, which is authoritative works. So works of authority, so a number of established political texts that are seen to be part of the Constitution. They explain how the Constitution is worked up and developed. So these texts again have no legal authority, but they have what we call a persuasive authority, as they can offer guides to make political decisions. So for example, A.V. Dicey's Introduction to the Study of Law of the Constitution is a good example of a source of a body of text which can be used as a guide to understanding and developing the Constitution. So it is seen as an authoritative work. Now the final source of the Constitution is one that's a little bit difficult to really understand with the whole climate of Brexit happening, the European Union, EU law. So in the UK, we became part of the EEC, the European Community, the European Economic Community, in 1973, and therefore there's treaties that established the European Union. This is an interesting political discussion since Brexit has happened. So if the UK leaves the EU without any deal, this could lead to a change in the UK constitution, since the treaties will no longer be binding, nor will the decisions from the Court of Justice. So what we have here is an example of a EU law being cut off from the UK completely, and that's if we leave without a deal. If there is a deal in place, a deal that sort of sets out the relationships between the EU and the UK, then it is seen that the UK and EU law, EU law is still in some part binding to the UK constitution. And it'll be interesting to see how this situation develops over the next coming months, to see how much of a change to the constitution Brexit will have.